Good afternoon, rather, to all of you and distinguished guests on the dais, ladies and gentlemen, and dear friends. After hearing my batchmate from college, Mr. Krishnan, we also entered the service together at the same time. I think there is nothing more actually I can say in terms of the basic structure of the Digital Data Protection Act and the way the implementation path has been configured by the Government of India. In fact, when we met him day before yesterday, we did some kind of conversation relating to implementation. I can tell you that the government of the day is extremely serious about implementation of this act. I have a prepared speech. Much of it has already been spoken about by Krishnan and Dr. Gulshan Roy, who has no storage limitation as far as information data about data protection and other things are concerned in his mind. Mr. Kailasam, of course, I have interacted both online and offline several times. I thought I would, given my experience of being in the Joint Parliamentary Committee on the Digital Data, at the time it was only Personal Data Protection Act, which was set up in 2019 subsequent to the Model Act, which was given to the government by Justice Sri Krishna, and which followed from the Puttaswamy judgment of the Supreme Court. I can tell you this much, that the consultation on the Act itself, the implementation aspect of it, went on for close to about 4 years, 2 years very intensely despite the pandemic. I know that I used to travel from Bhubaneswar almost every week, and Meenakshi Lekhi used to be the chairman, she used to be doing it, and after that Mr. P.P. Chaudhary came. So as far as the consultation across the stakeholders are concerned, I think there are 2,000 pages of submissions made by colleges, universities, fintech players, regulators, ministries, Minister of Home Affairs. All the consultation has, the point that I'm trying to make here is that this is an act which has been well thought of. Even though privacy has never been our virtue, the data has never been treated very sacrosanctly by citizens in this country. And that is also reflected in the fact that if you look at the Puttaswamy judgment and go 50 years back, public interest was more important, so everything has to be disclosed. And it came a full circle in 2015. Two judgments of Puttaswamy came in which the right to privacy was established as a fundamental right, read into Article 19 and Article 21. So there are two aspects into this implementation of the Act. First, if there is a legal problem in implementation by either the data fiduciaries or any of the data principals, what will it be tested against? It will be tested against the Puttaswamy judgment. Puttaswamy judgment says there are 5 frameworks: purpose limitation, collection limitation, storage limitation, quality, accountability. Now, this being the framework which has been taken from the EU GDPR, rather, the 2019 Act which was introduced much in the lines of the EU GDPR. One advantage of that was that EU GDPR had already seen by that time 2 years of implementation. Second, there is a provision of adequacy in cross-border data transfer. If one country feels that the data of its data or data of any of its company is going to another country where the data privacy standards are not adequate, then the transfer will not take place. So the safe way out was to have the EU GDPR, some kind of a structure. And as you used to say, I think Dr. Gulshan Rai also came before the committee, I think, several times to advise us. The framework was easy to implement because then the adequacy norm would be met. But then a realization came after 2 years, I think 2022, after about 3 years, that in a country like India, as Mr. Krishnan said, it is a Made in India Act. We realized that the context of implementation of a Digital Data Protection Act or a Privacy Act are different from Europe, or for that matter from any other country. We have a United States where there is no National Data Protection Act. There are states. California has an act, but still trade takes place. So the idea was that we will have a India-centric, favorable to the Indian Context Act. And the need of the hour at that time was that India's economy was being driven largely by the digitalization and digital economy of the country. So innovation was is still central to India's growth story, economic growth story. And therefore, a decision was taken that we cannot have a very prescriptive act like the EU GDPR. We will have a principle-based act where the broad principles will be laid down in consonance or in compliance to the Puttaswamy judgment, not deviating from there, but the finer points, the finer details would be left to the rules. The second advantage in that was and is that while an act requires any changes in the act or amendment in the act would require it to go to the parliament again, and there is a huge time lag in it, it is possible for a rule to be changed, and the changed rule could only be placed for 14 days in the parliament. So it is an executive domain, and the way technology is changing, as we are seeing with artificial intelligence models coming out, and we do not know what's going to happen so quickly in future. Technology regulation has always lagged behind technology historically, and that was going to be the case. The point is how less is the lag time, and therefore the prescriptions were brought to the rules. If there are problems in implementation, the rules could be changed. So I think the government's approach in 2023 in bringing a totally new act, a smaller version of the act with principles as the main portion of the act, and the prescriptions in the rules, was very pragmatic approach towards the India context. And therefore, my appeal to all of you, whoever is present here, to everyone who is not present here but who will be brought under the rigor of the act, has been brought under the rigor of the act, is that there is no further consultation as far as what the government wants or what India wants. Because when I say government wants, as I said, there were 2,000 pages of depositions from across stakeholders, all kinds. So all points of view have been taken in, and a conscious view has been taken that we will not follow a very strict regime of giving too much importance to privacy at the cost of innovation. But at the same time, we cannot deviate from the Puttaswamy judgment, where it is a fundamental right. Therefore, now the question is of implementation. Now, in implementation, there could be hitches, there could be problems. Dr. Rai talked about several such problems that could come up in the definition of digital data per se, in the definition of loss which has been defined there. You hear my speech in Parliament when this act was being passed. I still maintain the loss has clearly been written in financial terms over there, whereas a far more important loss is reputational loss, which probably cannot be quantified. Some kind of a tort will come, law of torts will come into there for compensation. It is not a part of the act now. I am confident that this will have to come in at some stage later by intervention of the Supreme Court, if nothing else, because some data principal will go and say that this has been misused by me, and this is the reputational loss that has happened to me or to my company. And then even in terms of penalty, it's one big penalty of 250 crores. I think I spoke in Parliament requesting it to be made, graded and linked to the severity of the breach or severity of the harm caused to the data principle. So some of those things will come later on. But the point that we are discussing today, and I'm so happy Data Safeguards is doing this today, starting with Delhi, and I had requested them to do it across India, starting with the bigger cities, is because, trust me, I don't really think that you can expect an extension of the time. In fact, I think he didn't say, but this was mentioned someone here, but the idea is that to truncate this time, to make it smaller, the window of implementation smaller. There are two reasons for it, which is not being mentioned, which I'll guess. I was a member of the Finance Committee for 5 years and Joint Parliamentary Committee on Data Protection for about 3 years till the Act was passed. In the Finance Committee, 5 years, where most of the financial institutions, DSI, everyone is to come. And in the Act provision, if you look at the 2019 Act, the Data Protection Authority was supposed to be signing separate agreements with separate regulators, and it was very complicated. We have now simplified in this particular Act by saying that each of the separate regulators, that is sectoral regulators, may have a much more stringent data privacy norm beyond what is already been given in this Act, if you read it clearly. And that has been made possible because the principle has remained the same. And it can come through regulations, it can come through courts. When the Data Protection Board comes, it can also come through a mutual agreement. So as far as RBI is concerned, that is the financial sector is concerned, data localization is there, though it is not there in the Act. And the definition of critical data and all that, which was there in the 2019 Act, which is there in EU GDPR, has been removed. But the understanding is that during implementation of this Act, some of those some of these classification would be required. In technological terms, in IT implementation, we used to use a term called data dictionary, which basically used to pick up each data and categorize it and talk about the data, and it's a kind of a catalog. I believe the Data Safeguards product which they have launched really takes care of this, because that would be very essential at some point of time, because different sectors would require different level of privacy. Health data was talked about. Health data would definitely require a much stricter privacy norm than what has been prescribed, principle remaining the same. So a very well thought out product in terms of regulation has come to you, and as has been mentioned, it is not really a question of coercive regulation that the government is pushing. Mr. Krishnan made it very clear, all of them made it very clear. You have to think about privacy by design for neo products. For legacy systems, you add value by becoming compliant to the data protection law. I will bring I'll talk about an example illustration in the current context, which is climate, green economy. So when we talk about climate, this discussion has been going on for several years, Paris Accord, until now, that if you want to make your economy green, if you want to decarbonize your industries, your cities, your governance, then it would require a huge amount of adaptation funds. This is what is the discussion and talk about climate justice and all that. But look at India. India has been delivering one of the highest economic growth by still remaining extremely green. Our achievements in solar power generation, we are beating the target of which we had set for ourselves. In terms of conversion of shifting to renewable energy, in terms of conversion to electrification, transition to electrification, everywhere the pathway is becoming green, and still we are able to manage economic growth excess of 6% or 7%. So green growth has happened despite remaining green. So net zero, I have always maintained, and Jayant Sinha maintains that with me, net zero is actually net positive for the economy, for the people of the country, and for the global, for the world at large. The same thing I would say about companies that implement the privacy law. It will be net positive for them. Why? Number one, they gain consumer trust. Of course, that's important. They become compliant with the law, so the chances of huge penalties will be less. But the most important thing is trust. When the consumer or your customer loses trust, it not only affects your bottom line, top line, it could also affect your brand value, which you have taken years to build. Now, this was not probably being discussed earlier, but now this will be discussed everywhere. And as I said, the benchmark it will be tested against is the Puttaswamy judgment. So if I'm not happy with a particular data fiduciary being supported by the data protection board, as far as a breach letter is concerned, as a data principle, since it is a fundamental right, I could go to a constitutional court and enforce my right. And in that case, if the court gives a judgment against the board or against the company where the data breach has taken place, imagine the tremendous amount of brand loss that would happen to the company. Now, this debate was not there earlier, but this is going to happen when customers become or consumers become aware, including the e-commerce platforms. They will face this. It's not just the consumer court. It will be the privacy law itself. And therefore, it is very important that instead of waiting for a time in which hoping to see how the implementation will take place, whether penalty will be imposed or not, the smartest thing would be to start implementing it in the quickest possible time. I am an independent director in India's second largest electric mobility company, which was previously Amar Batteries, Amar Raja Batteries. And I have been telling them that the most important thing now is to implement this. Yesterday only I sent to the board meeting that you bring it to the board, because this is a thing which has to be discussed at the board level. The CIOs here have to ensure that it comes to the board level, because the implementation will be across the company. It cannot be that the staff of the CIO sit down and start marking data manually and seeing which one is coming from where, whether it is personal data or not, whether it is digital or not. By the way, everything is now digital, because the definition is that even if you take a photocopy machine and use a photocopied document and use that, that's the digital data. Still, there will be some manual data. That is something which I'll discuss later. That was also discussed by me in the parliament, because I still feel there are some manual data which will be left out, which will still be personal and can be collected, and possibility of creating harm to the individual. Now, the point here is that a situation will come in which the buyer, the customer, will start asking the question that, just like in the cars, does it have a seat belt? Initially, what happened? When the seat belt was being thrust as a safety measure, people used to ask, this an upfront cost, additional cost, why to pay? But now, what is the culture? The culture is whether there is all the safety requirements, not just the belt, but whether the balloon is there or not. The safety balloon is there or not. Similar will be the questions that will be asked by your customers, whether privacy or whether my data is safe if I'm sharing something. The another point which is very important, which has indirectly been talked about, is data minimization. My personal belief is that implementation of the digital data protection law, adherence to the privacy norms becomes easier when you collect the least amount of data. Least doesn't mean to affect your business, but only optimal amount of data, or let's say not least, but optimal amount of data that is only required, and not data which is not required. It doesn't only violate the privacy law, because you have to also protect that. You have to protect, you have to put in structures to protect the data which is not useful for your business. It will also take your storage cost. It will increase your storage cost. And storage limitation, which has been, which is not explicitly mentioned in the Act, but it is a Puttaswamy judgment thing. What flows out of it is the right to be forgotten and right to erasure. So, and privacy by design, which has been talked about by Mr. Gotse, in the initial 2019 version of the bill, privacy by design was a separate chapter brought from the EU GDPR. Here it has been made implicit because it has to be by design for a new system. For a legacy system, you really have to, well, I think it is a little tougher definitely, but the work has to be done. And to the as an answer to the question as to why government is thinking of shrinking this time frame, it has not explicitly been mentioned, but my guess is, because I was in another committee, I think on commerce, most of the bilateral FTAs, free trade agreements, have a clear, huge provision relating to cross-border data transfer. If the country which is going to send you data and you're going to do trade with that country, if it is not confident that its citizens' data or its industry's data will be protected on a law which is acceptable to them, trade will not take place. I can tell you on this particular point itself, when I was in Brussels, I think 2 years ago, this discussion was there. EU ambassadors and Indian ambassador to EU, this discussion was there. It had got stuck only on this. So I have a feeling that the government would also like that the implementation of the Act happens quickly, because cross-border transfer of data, as a consequence of increasing trade, will make this a necessity. So those of you who are also selling things or exporting would probably be facing this challenge even more. There are areas in which I know that the data safeguard has got a beautiful product, but I'm sure I must tell them that I foresee a number of changes to the Act, and rules definitely much more, happening very regularly, and therefore it should be very malleable and adaptable kind of a system. For example, we have got the provision of the Act says of the Government of India, through rules, publishing list of countries to which data cannot be transferred. The Indians' data cannot be, that's blacklisting. Initially it was whitelisting, but we converted into blacklisting smartly. That is a smart thing. But what happens when data which is traveling to a whitelisted country goes to a blacklisted country and again comes back to the whitelisted country? So a situation will come when a breach takes place that a company in India, or even for that matter Indian government, if government data is involved, would like to know how a breach has happened, which may have caused harm to the country as a whole, or may have caused harm to a company in India. These are issues which will come up. And therefore, I have also firmly believed, and I've told this to the minister, both of us came to the parliament at the same time, we have worked together in Orissa also, that a situation will come for international settlement or arbitrage, WTO kind of stuff. And I had mentioned this, Mr. Prabhu, who is to be there, Suresh Prabhu, also supported me in this, because I foresee a situation where this kind of body would also be required to settle disputes between countries, between companies in different countries, while cross-border data transfer, when there is a breach of data, when a cross-border transfer is taking place. I will not get into further details. I would only end by saying that it is often said that every idea has a time. So the idea of privacy, this is the time. No, I think this time was there yesterday, day before. We are late. If we want our trade and commerce to increase manifold in a highly competitive world, non-tariff issues like privacy could become also a factor. all these issues would come up. So the smartest thing would be to start implementing the Act provisions, the rules. The data safeguard, I must make it clear that I am a senior advisor to them, more out of love for the subject and also because they belong to my state, Orissa. So I can only tell you this much, that their product is very good. I've now suggested that they should make it more prone to change, because changes would be required quite often, both by government as well as by courts. And courts here means both High Court as well as Supreme Court. There are 30 High Courts in this country. Not every decision of the High Court comes to the Supreme Court. But what has happened here is that they have developed a product which is a platform based. It goes there, it sits over there and detects which is the person. I'm sure I've not gone through all the modules, but I can say that it should be applying the principle of data minimization first. What is required for the industry and what is not required, then don't store it, don't keep it, leave it, don't collect that data. Whatever module follows. The next thing is, and very important, I talked about my being in the board of Amar to basically talk about this issue of outsourcing. Now there are franchisee models, there are franchisees who are collecting data and selling batteries and other kinds of stuff. Now they will also have to follow this. Of course, the Act provision is very clear. The data fiduciary who collects the data is responsible. The processor, in the initial version of the Act, even the processor was responsible. But what happens is, in real life, the point would be a processor cannot, there could be processors who could be only doing processing of data collected from the data fiduciary, but I'm sure most of the data processors would be collecting data themselves, some portion of it as data fiduciary, to develop a model or to develop an AI algorithm or whatever. So everyone would be brought under the ambit of this Act, whether you like it or not. You cannot really say that I am not a data fiduciary and therefore I am outside the ambit of the provision of this Act. And those in the financial sector, insurance sector, those in the lending sector, they will have to be extra careful, as I said, because the sectoral regulator has become stricter in its interpretation of the adherence to the privacy law. So they have talked about data localization. National health statistics is being collected. You know that we're developing the health statistics across the country. The new authority which has been created, almost in the lines of the Aadhaar, Unique Identification Authority. Now they will be coming out with also their separate regulations relating to privacy norm flowing out of these provisions, but I am sure it will be much more stricter, understandably so. What will be required in agriculture may not be that important. Whatever is personal data for health may not necessarily be personal data for health, agriculture sector. So these would be developed. These would be different. In the era of AI, when clear audit trails are difficult to establish, this will be put to test several times. Any data breach happening or any harm being caused to a data principal because of data which has been collected by him by some data fiduciary, but has been used in a huge smaller algorithm models to give a particular output, has caused him harm, then I think the Data Protection Board will have a difficult time in establishing these trails. So while implementing it, I do not know what the product does, but I can tell you this much: establishing or maintaining the clear audit trails to show where, if and at all, a breach happens, you have to fix accountability. Because if you do not fix accountability, let's say a data breach happens, a financial loss happens to a particular data principal, he files a police case. The police, FIR cannot be, it has to be against a company or against an individual. It cannot be also a company, it is an individual. Now, if the FIR is being filed and if the accountability cannot be strictly fixed because of a lack of audit trail, then it actually reaches the higher levels of the company against whom the FIR would get filed. So these will be issues which would come up. You will learn, or all of us will learn, when we actually implement it. But The time is now. We have lost, I think, time in implementation of the act. We have to actually be doubly quick. And as I said, the government could actually be under pressure to hasten this time because of the need to sign the FTAs as quickly as possible with more countries. The EU FTA clause has been finalized, that's why, because the moment we've had this act and had these rules, it became smoother to sign because that particular clause in the FTA could get settled. USA, it should be easier because USA itself doesn't have a national level regulation. But Germany has 3 tiers. So Germany would be difficult. Australia has recently got a data protection law, so it should be easier. So what I'm trying to say, the implications are huge. The best is to adopt it as a force multiplier, as it will add to your business growth, as something which will actually make your business plus plus. Just as net zero is now net positive for Indian economy, it will be plus plus for you. Thank you so much, and I look forward to the deliberations that's going to happen here.